Hello, I am Dr. Pallavi Gupta. I will take up healthcare law as a subject. The topic for the day is constitutional provisions related to healthcare. I will discuss meaning of health and preamble under the Constitution of India, health and fundamental rights under the Constitution of India, health and directive principles of state policies under the Constitution of India, health and fundamental duties under the Constitution of India, health and seventh schedule under the Constitution of India. What is the meaning of health? Health is a vital indicator of human development, and human development is the basic ingredient of economic and social development of a country. According to WHO, health is a state of complete physical, mental and social well-being, and not merely the absence of disease, infirmity and sickness. There are several constitutional provisions which are related to healthcare. The Constitution of India, directly or indirectly, not only provides for the health care of the people, but also direct the state to take measures to improve the condition of health care of the people. The framer of the Constitution had imposed the duty on the state in the nature of directive principles of the state policy, wherein it is the responsibility of the state to ensure social economic justice to its citizens, as the preamble of the Constitution says. The term right to health is nowhere mentioned in the Constitution, and the Supreme Court has interpreted it as a right to health as a fundamental right under the directive principles of state policies and fundamental rights. Beautifully, Supreme Court interpreted first right to health under Part 4 of the Constitution of India, and second, right to health as a fundamental right under Part 3 of the Constitution of India. Supreme Court said the right to health is a part and parcel of right to life, and therefore right to health is a fundamental right provided under the Indian Constitution. Now I will discuss the provision of preamble of the Constitution, what it says about health. The preamble of the Constitution of India strives to provide for the welfare state with socialistic pattern of society. The concept of democratic socialism aims to improve the health condition of the people. The preamble gives a broad direction for the Indian Republic, refer to social, economic and political justice, and also equality of status and of opportunity. Under the term social justice, one can raise the issue of access to health care facilities and the principle of justice involved in the equality of access to the health or medical facilities. In the same way, equality of status and opportunity may be taken to refer to improve the citizens' socio-economic and health issues. There are a number of fundamental rights which are mentioned under Part 3 and indirectly related to health. Article 14, fundamental right refers to equality of law and equal protection of law. Therefore, there shall be equality of status and equal protection of law for all citizens in matters relating to any state-run healthcare institute. Under Article 15, which is saying there shall be no discrimination. So therefore, no citizen shall be discriminated by state-run healthcare institution for medical treatment or any medical facility on any ground. Article 21, which says that right to live means something more than mere animal existence and include the right to life consistently with human dignity and decency. In number of the cases, the Supreme Court held that right to health and medical care is a fundamental right, which is covered under Article 21. which says that no person shall be deprived of his life and personal liberty except according to procedure established by law. Since health is essential for making the life of workman, man or woman meaningful and purposeful and compatible with personal dignity. Article 23 is indirectly related to health and it refers against exploitation. Subclause 1 of Article 23 prohibits traffic and begar in human being. It is well known that traffic in women leads to prostitution, which is turned is two major factor in the spread of AIDS. So prostitutions are also having right to health. Article 24 refers against exploitation. It is relating to child labor. It says that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Therefore, this article directs the relevancy to child health. It also indicates the responsibility of the state to consider the health status of young citizens, children, while giving employment to them. Thus, health status and physical fitness in cases of some occupations are considered as a precondition for employment. Since these rights are justiciable, the state gets an authority to impose its preferences on the citizen in interest of maintaining good health condition in the country. Now I will discuss health and directive principle of state policy under the Constitution. Article 38, 39, 41, 42, 47, 48 deals with the directive principles of state policy related to health. Under Part 14, 4th of the Constitution outlining the directive principle of state policy, there are a number of unstated references to the health development of the people. In fact, the fundamental right and the directive principles constitute a conscience of our constitution maker. It is true that the directive principles of state policy are not justiciable, suggesting that the state can excuse itself from implementing the various provisions under the head of directive principles. However, the content of the directive principle indicate the concern and the commitment of the Indian Constitution for social welfare and equality do provide a definite direction for the policy making in the country. These provisions had directly or indirectly imposed duty on the state related to public health. It directs the state to take measures to improve the condition of health care of the people. As Article 38, 39 is talking about to maintain the social order and to protect the health of the worker. As per directive principle of state policy, there are certain principles of policy to be followed by the state referred to health and development of the people. It is said that the state shall in particular direct its policy towards securing that the citizens, man and woman, equally have the right to an adequate means of livelihood, that the health and strength of the worker, man and woman, and the tender age of the children are not abused, and that citizens are not forced by economic necessity to enter the avocation unsuited to their age of strength. The children are given opportunities and facilities to develop in a healthy manner and in condition of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Such policy clearly shows responsibility and a concern that the state should have towards physical and psychological health of the Indian citizen, irrespective of their social, economic and demographic situations. Article 41 says that state has to provide public assistance for those who are sick and disabled. The provision also shows that as far as possible the state should strive to assist the citizens by physical and financial provisions in the situation of old age, sickness and disablement. Hence, under the mandate, the state is required to provide the public health and medical care preventives as well as curative and promotional services in the field of health. Article 42 puts a primary duty of the state to protect the health of infant and mother by maternity benefit. This implies that it is not only the sick or disabled person which require the state to intervene, but it is also under the normal situation of the work and the normal experience of the citizen under certain situation that the state should provide the needed assistance. Thus, the state has to intervene to secure for these citizens proper human condition in the place of work. Such condition of work should be available to all citizens irrespective of their gender, religion, language, community, race, etc. means without discrimination on any ground. Even though it is normal occurrence for the women, the maternity puts upon them great stress and mental tension. The state need to provide the relief. This may take the form of financial assistance for antenatal and postnatal care and providing the facilities for such care. Article 47 speak about the duty of the state to raise the level of nutrition and standard of living of its people as primary responsibility. Due to a number of factors, historical, socio-economic, genetic, etc., all the citizens do not have the same level of nutritional status and health status. It is observed that the children of socio-economically deprived communities are highly prone to disease on account of the poor nutritional intake. The same problem is seen in the case of women of the socio-economically deprived section of the population. The directive principles of state policies prescribe as the duty of the state to raise the level of nutrition and the standard of living and to improve public health. In this context, the state is required to take steps to bring about prohibition of the consumption except the medical purpose of the intoxicating drinks and of drugs, excessive doses of which are injurious to health. This indeed a clear-cut articulation of fraternal role of the state in protecting the health of citizens according to the Indian Constitution. Article 48 is talking about to organize agriculture on the modern and scientific lines so that it can improve the productivity. Article 48A is talking about duty of the state to protect and improve the environment to safeguard the forest and wildlife of the country. The Constitution also referred to the preservation and improvement of the healthy environment, which is so crucial for the improvement of health status of all living being. Not only the state but also panchayat, municipality and local self-government are liable to improve and protect public health of their locality. The legislature of a state may endow the panchayat with necessary power and authority in relation to matters listed in the 11th schedule. So we have seen in number of the cases the Supreme Court held that people are having fundamental right to live in clean environment, or in a Ratlam case it was municipality or the local community was directed to take measures to make clean the city. Now I will discuss health and fundamental duty under the Constitution of India. Fundamental duties are also indirectly linked with clean environment, health, etc. Just as there is a requirement that the state shall have to provide certain facilities and services to the citizens, the Constitution provides about the reciprocal requirement in the form of fundamental duties of the citizen towards the country. So it is the duty of the citizen that is fundamental to protect and improve the natural environment, and to develop the scientific temper, humanism, and to strive towards excellency in all spheres of individual and collective activity, so that the nation constantly rises to higher level of endeavor and achievement. In this sense, there is a joint responsibility from the state as well as the citizens towards the maintenance of human and animal health, as well as also the long-term issue relating to improvement in the health condition of the human being and the animal. Thus, the issues of the health and the issues of the decision making and administration are attempted to be integrated in the Indian Constitution. Health and seventh schedule under the Constitution of India. As we know, in seventh schedule we have three lists which are mentioned about the certain entries on which central government or in the state government and can make law. There is concurrent list on the entry which is mentioned in the concurrent list. Both the government can make the law, and here I will discuss some entries which are related to the health and mentioned in the union list. There are number of the items related to health services and health status of the people mentioned in the unit list. These items are considered as port quarantine, including hospitals connected therewith, Siemens and Marine Hospital. As we have seen during pandemic COVID-19, central government has taken the make the regulation to stop the person who are coming from abroad and taken them for quarantine, and cultivation, manufacture and the sale for export of opium, interstate quarantine, duties of excise on tobacco. Under the state list, there are number of the entries which are direct reference to the provision of healthcare facilities. For example, drinking, health and sanitation, including hospitals, primary health center and dispensaries, family welfare, public health and sanitation, hospital and dispensaries, production, manufacture, possession, transport, purchase and sale of the intoxicating liquor, water, overall supervision of the function of the hotels, fairs, so that these would not cause health hazards, levying excise duties on the alcoholic liquor for human consumption, opium and other narcotic drugs. Under the concurrent list, the following items are included under the concurrent list known as a list third, which refer to the various aspects of physical, mental and social health care policy. The policy with regard to drugs and medicine, etc. These items are as lunacy and mental deficiency, including place for reception or treatment of lunatic and mental deficient, adulteration of foodstuff and other goods, drugs and poisons, population control and family planning, old age pension and maternity benefits, medical education and universities, vocational and technical training of the labor, prevention of the extension from one state to another of infectious or contagious disease, trade and commerce in and the production, supply and distribution of foodstuff, including edible oils and other oils. So it is clear that the Indian Constitution expresses its deep concern for the health of human, animal, plant in India. In case it has been seen that the Indian federal setup, different layer of government have been vested with different responsibilities towards various aspects of health. There seems to be a clear socio-economic, rational and administrative expediency in assessing these responsibilities health issues. The Constitution also stipulates certain duties for the citizens towards contributing to the promotion of health and the country. Therefore, the Indian Constitution has exhibited its appreciation of such a comprehensive perception of health for law. So, I have discussed various constitutional provisions which are related to health directly or indirectly. Whether do we have right to health, a fundamental right to health, that we will discuss in the next topic. What constitutional remedies are available for right to health? Thank you. Thank you very much.